took permission.
Doesn't matter.
I took permission from my
It's
lord.
okay.
My lord, there is one matter to be moved tomorrow, if your lordship kindly allow. This is in respect of an advertisement your lordship has dealt. Earlier also I have been told that in respect of advertisement issued by the technical education of lecturer in this polytechnic. There is an advertisement which is issued. My lord, advertisement is not a problem. It will start now. Your lordship remember that they said that this technical teaching and skill proficiency 25 marks will be given. Now after that, now they have notified freshly what are the subject in teaching and skill proficiency test. Now this is we have been shocked, my lord, how this notification has been issued, and this is not a part of AIC regulation. AIC regulation. Secondly, all these are when you are appointed a lecturer, you are sent for training. Thereafter, all this comes.
To make AICT a party, because I think
Yes,
the AICT
AICT
regulation is.
We
also
made
there.
AICT party also.
Okay. I don't know
Not
who is appearing
intention.
for who is
Your
appearing for
lordship will
AICT.
not think for a minute also not an intention. The advertisement is not only, and they said that your past services will be counted. Past services. We thought teaching and skill proficiency past services will be counted. Some marks will be given to us. Completely so something U-turn they make and said these are only when you get experience.
Any date has been fixed for the interview?
No, I think
because
38.
written test is also there,
38. 38.
30 is the written
30 year written test.
Thereafter only we are selected. They will
Yes,
call for
it will later on. There's some process are there,
Okay.
deeply.
Made with lordship's value. I beg to mention item number 37, the medical admission matter, that tribal girl your lordship have dealt with once, and I have also viewed the order, my lord. Can it be? I have also taken the consent of Mr. Buddha Gogoi. Can it be taken at 2, my lord?
Today we have interview. Today, tomorrow.
So, my lord, can it be on 2nd, my lord? There will be some urgency. That's why.
We understand. We can have it on third, second half.
Second.
Third on second half, as of now.
Third
second, we have lots of cases in the board.
Third, my lord, my miscellaneous matter day. Can it be on hearing day, my lord?
Hearing day, you know what happened? All the second, fourth, then again on 13th, 11th, whatever.
8, my lord. 8 May.
8 you want?
Yes.
Fine. On 8.
Let's fix item, my lord.
May I please, your lordship? I filed an IA. I filed an IA on 19th, my lord. For the imprint, my lord. Some urgency. Can it come up next third or fourth?
See, for implement.
Yes, my lord. Some urgency. Some urgency.
On third, but make a mention it is for implement. You can upgrade it and take up an act.
My lord, in item number 19, my lord, on the last occasion, inadvertently, the interim order was not extended. So I filed an IA, my lord. That may be allowed to be tagged with the records. And my lord, in other items, so I have filed an affidavit.
May it please your lordship. My lord, I beg to mention item number 12, lordship. I received the RTI report, lordship. I want to file an additional affidavit on that, lordship. And I have a consent from the other side, lordship. And they also want to file their affidavit, lordship. So I pray, lordship, that observation may be, I may be allowed to file additional affidavit.
Matter is adjourned for a period of 3 years. The lister on a individual. The petitioner is allowed to file additional affidavit.
And one matter, lordship.
You can reply. Yes.
Sorry. One matter, lordship. Earlier, lordship, before 6 months back, lordship, notice was issued, lordship, that regards to the relating to appointment of the teachers of Hailakandi district, lordship. I pray not yet come, lordship. I pray, lordship, next week, any days, because they are going to appoint, lordship, some
On 4th.
On 4th, lordship.
Yes.
May it please, your lordship. My lord, I have filed an IA on 4th of April for withdrawal of a writ petition. If it is possible tomorrow or otherwise as per convenience.
On 3rd.
On 3rd of May. Obligement.
My lord, I beg to mention for listing for withdrawal one writ petition, your lordship.
3rd.
Obligement.
Your lordship, I beg to mention one item for listing an IA on WPC. It's related to Dibrugarh University and expulsion. There is an urgency. Can it be listed as early as possible? Any date in your convenience.
Fourth.
Obliged, your lordship.
Please, your lordship. My lord, I beg to mention item number 17. I'd like to withdraw that petition, my lord.
Just wait for a few minutes. As soon as the mention is over, we'll pass the order.
Okay.
May I please, your lordship, I beg to mention WPC 7613 of 2020. 13 of 2022 for listing, lordship. Matter pertains to non-payment of salary even after provincialization of services, lordship.
Whether the respondents have filed any affidavit?
Pardon,
yet.
lordship.
Whether the respondents have filed any affidavit?
Uh,
No idea. Okay, we'll have it on 8 May.
Lordship, it is part of a series. The series may be listed
a
along.
series?
Yes, lordship.
Okay, we'll verify. It will be on 8.
Much obliged.
May I please, with the consent of the other side, I beg to mention item number 25 and 26 of daily list, my lord. In this case, my lord, yesterday we have received an affidavit in opposition, my lord, filed by the government, my lord. We want 2 weeks time to file and reply on that. Obliged, my lord. Obliged.
May I please, your lordship. My lord, I beg to mention for listing of a writ petition, lordship, which was last listed on 15/3, lordship, but due to paucity of time, lordship, it could not reach, lordship. On 4th, lordship, next week, any date, lordship.
4th, board is full.
Or
that's the
5th,
reason.
lordship.
5th is holiday.
Oh, sorry, lordship. Then
8, Monday.
obliged, lordship.
My lord, motion matter, my lord. May I play on 3rd, my lord?
What is that? What's the urgency? What is the urgency?
Urgency, my lord, contempt motion. Your lordship passing order for
Okay, on
listing
third.
after verification.
Yes.
Your lordship, I'm paying for listing of a writ petition, matter pertains to provincialization. May come up next week, any day.
It's a fresh writ petition or pending?
And come up, it may come up for orders, lordship.
For orders. On 3rd, right? Don't know.
Please, your lordship. I beg to mention item number 7. My senior, Mr. H. Shaman, is unwell, my lord. May I pray for
Have we informed the other side?
Yes, my lord. My
I am for
friend
the
is
expiration of lordship. Yeah, lordship, in the main case, lordship, link has already completed lordship. Lordship, main case may be listed for admission column, lordship. Last of the lordship also proposed to.
Okay, we'll have it on 10th
Yes, lordship.
for admission.
In admission column, lordship. Obliged.
Item number 17.
Not Mr. Jayawardhan, learned counsel for the petitioner. And Mr. A.R. Tafil, the standing counsel, higher education. For the response number 1 and 3. Mr. Tita, MS. G. Pegu, Government Advocate Assam. For the response number 2. You are appearing for whom? For response number 4 and Mr. Arkarin and counsel for the response number 5. On instruction of the petitioner, Mr. Abedin Lanet counsel. For withdrawal of its petition. To which the counsel for the respondents have no objection. Petition. The interim order passed earlier.
It's already vacated.
Vacated.
Yes, yes. That is the reason.
Oh, in IA.
Yes, yes.
That's the note.
IA 5 and 6 both have been liquidated and interim being vacated, and they have been now appointed.
View of it is to be noted here that the interim order passed earlier 3108/2022. Then vacated on 15/03/2023.
Wait, please, Your Lordship. Lordship, I am on behalf of respondent number 3. Lordship, I need some time for instruction.
What's your good name?
Jedas.
Kindly see the last order, my lord.
MSF, the judge very lengthy defense on behalf of the accountant general. That's number 3. Wait for some time. Wait the relevant happening in the back. The accountant general Assam is already a party respondent in the present proceeding. And by order dated 12/04/2023, court directed to make the accountant general AN Assam and the party respondent number 6. Instead of making the accountant general AE Assam party respondent number 6, the respondent number 3 accountant general Assam to be corrected as accountant general AE and struck the name of the respondent number 6 accountant general Assam as the party respondent. On the next page, the respondent number 3 accountant general AE Assam shall apprise the court about the status of family pension payable to the petitioner on the death of her husband Duron Deka a grade 4 employee peon in the Teachers Training College, Mongol. Who died on yes, Mr. Sir, when did
Page 29, my lord. Page 29. 13/8/2008. Right on.
13/08/2000. list on 16th May, but we want to know the status.
Apply.
My lord, instruction is called for.
Yes, sir.
Yes, may I please go ahead. Shiva, I would like to place the office memorandum that was issued by the budget department for payment of arrears salary in this fund. Because my lords, here the amount that is pending to be paid to the petitioner, my lord, that will be considered in the as a arrear salary only, my lords. In the OM lordship, it's mentioned, lordship, if I may read, it's third line from the moreover, finance department cleared numerous arrear salary proposals during the previous financial years, because of which number of claim for arrear salary should come down to minimum. For disposal of these proposals and also for any fresh proposal in respect of retired, expired or in service government, concerned administrative department shall examine such proposals and consider for issue of sanction of payment of arrear salaries / DA, etc. from their end, subject to observance of the following conditions in addition to conditions laid down in this department's letter quoted under so and so. Worship, in para 1, lordship, the expenditure shall be debitable to the sub detail head of accounts arrear salary, my lords. They have their own account for that under the respective major minor sub head of account from which the salary of the concerned employees are debited, my lords. He's already getting his current salary, my lords. He is claiming for his arrear salary. In case there remains no insufficient provision under sub detail so and so 12 variant, under the respective minor / subhead of account, the administrative department shall look into the overall savings under 1 salaries under the respective minor subhead of account by examining the information required to be furnished by the concerned DDOs as envisaged in the letters under reference. And if the administrative department is satisfied that there shall be remain sufficient savings at the end of the year under the particular head of accounts in question, then the arrears may be sanctioned by the administrative department, my lords. The administrative being the education department. The department shall take special care on assessing the savings so that the payments of regular salary are not affected during the year, my lords. Point 7, my lordship. Second page. Before issue of sanction, the administrative department shall satisfy themselves on the admissibilities, authenticities of claims received from the DDOs, examining the non-drawal of arrears or any part thereof on any earlier date.
This is still in force?
Yes, my lords. This is
of 2011.
2011, lordship. That has been followed since 2011. There has been no change.
Now, while making such payment of arrear salary, if the administrative department is satisfied,
yes, lordship,
on the proposal or the whatever is submitted by the DDO,
yes, lordship,
then if it is wrongly paid, what will happen? So there is no requirement of approval of the finance department.
Lordship, if there is any shortfall, then a proposal is sent to the finance budget department. That is because the verification part, lordship, is specifically mentioned that has to be done by the DDOs because they are the bookkeeper and service record keepers of the petitioner, my lords. For necessary verification or cross verification, the finance department needs the record, my lord. Only if a proposal is sent, only then they can consider the service record.
Now just tell us whether these particular office memorandum or the notifications or whatever communications are available with all the DDOs or not?
Yes, lordship. Lordship will see this has been marked to all page 1 to all administrative department, all heads of department, all deputy commissioners, and lordship, this has been practiced since 2011. Lordship, this is how the arrear salaries have been paid. Now, in the case of the petitioner, my lords, here for the period.
Okay, we'll make it clear. Heard, Mr. Emily, counsel appearing for the petition. Mr. P.K. Bora, standing counsel, Department of School Education, for your response numbers 1, 2, 3, 5, and 6, as well as Mr. A. Chalia, standing counsel, finance. Pertaining to drawal of arrear salary, the state government in the finance department long back made a communication under memo number BB.85 98/CC1 dated 21/10/2011. Mr. Chalia, Standing Council Finance submitted on an inquiry submitted that the said communication regarding the Royal of Arrears salary is still in force, which provides for various guidelines and a procedure for drawing of area salary by the DDOs in the concerned administrative departments, including the education department of the state. Mr. Chalia further state that the said communication dated 21/10/2011 was made to all the administrative departments, all heads of department, and all deputy commissioner / subdivisional officers. Copy of which has been placed before the court today. Mr. Chairman. Mr. Saliha shall furnish a copy of communication dated 21/10/2011 to Mr. P.K. Bora, Standing Council, Department of School Education, during the course of the day, which Mr. Bora shall furnish it to the Secretary of the Department of School Education, who in turn shall forward it to all the directors the district heads to the directors, all the directors under him. The said director in turn shall communicate forward said communication of the finance department to the dated 21/10/2011 to all the concerned district heads under them, who in turn shall forward it to the respective inspector of schools, district elementary education officers, deputy inspector of schools, block elementary education officers under them, and those DEOs, DIs, and the BEOs shall forward the said communication dated such and such of the finance department pertaining to drawal of area salary to all the DDOs of the respective educational institutions, provincialized, government, etc. Further, the Director of Higher Education Assam shall do the needful by forwarding the said communication of the finance department dated such and such to all the DDOs of the provincialized colleges of the state. The entire process shall be completed within a period of on or before 26th of May 2023, and the concerned directors, the inspector of schools, the DDOs, the DIs, and the BEOs shall furnish their respective reports regarding furniture of the said communication dated 21/10/2011 of the Finance Department refunds and videos, furnishing the report triggered in it. Submitting such and such, communicating such and such all the details. Pertaining to educational institutions, provincialized of the government educational institutions. Placed according on 1st of June. We'll see thereafter to make the process. Copy of the communication dated 21/10/2011. Placed before the court today by Mr. Chalia. Finance pertaining to royal and arrears and the guidelines related to royal arrears issued by the finance department of the state. They kept as a part of the record.
Plus.
Verma. David Justin.
Yes.
Mr. Chaliha. Mr. Salia, can you provide us the ACPS and MACPS guidelines?
Yes,
you
my
have?
lord. I can, Lordship, I can find out and I can give it
to us.
Lordship.
Probably the ACPS started with 2011 or something.
11, yes, Lordship.
And the MACP started sometime in 2017.
Lordship, I am not sure, Lordship. I have to
I
confirm.
tried to find out on the website. I think it is in 2017, then 19 and 20. Some again 2020 probably there was another guideline.
Yes, Lord.
Clarifying the 2017 how is to be assessed and whom to be given.
Yes, Lordship.
If you can give it to us.
Yes, Lordship.
Give it the note. We'll
Yes, Lordship, that I can just.
Please
I'll
find
just
out and give it.
Yes,
to us.
Lordship, I'll give it.
Yes, Mr. Dury.
Well,
3 and 4
years
on 23, my lordship has directed me to bring instruction. My lord. I have communicated, but I have not received the instruction. My lord.
Who is supposed to give the instruction?
My lord, district elementary education officer. My lord. I have forwarded from my lord director. My lord. My lord, lordship, grant some more time. My lord, I'll bring the instruction. My lord.
Mr. Bora, just two things.
My lord.
Mr. Dury, you have to also clarify.
Yes, your lordship.
Petitioner was an OBB teacher initially in a fixed pay.
Yes, your lordship.
That appears on Annexure 1,
Yes, your lordship.
page 14.
Yes, your lordship.
Now, terms of the order of the court, probably the order of the DE, her service was brought to, adjusted and regularized against the vacant post in a fixed pay. By order of 28th of July 2010.
Yes, your lordship.
And she went for probably training.
Yes, your lordship.
She was an LP school teacher.
Yes, your lordship.
Now, how come the DO in 2020 placed her in a ME school? Because those government letters are of 1986, 1988, nothing to do with the OBB 7066 that was appointed in 2020. Can you tell us how the DO in 2020 adjusted the petitioner against a non-planned post in a ME school? Please come to page number 20.
Yes, your lordship. This is an order passed by the DE, your lordship.
How come? He is not the authority.
I am not aware of.
He is not the adjusting authority.
Yes, your lordship.
And Mr. Bora, these are the things.
My lord, here, my lord, in persons of the government letter dated 1986.
It will not be applicable for the petitioner.
My lord. Well, I'll bring instruction, my lord, regarding this one.
Now, these are the things which you need to clarify.
My lord.
First of all, the petitioner has to pass the junior basic training
My lord.
after her regularization as an OBB teacher.
My lord.
We do not know in which year she passed, whether in 1 year, 2 years, 3 years, after third attempt, fourth attempt, or first attempt. And why the DO Dhubri have adjusted her service only in 2020?
My lord. It's a non-planned post.
Because all the OBB teachers have been regularized against the non-planned post way back in 2010 after the division bench judgment. So, there has to be some reason.
Some time may be granted, I will bring the instruction.
We will dispose it of. No point. Heard Mr. T. Dury, counsel appearing for the petition. And then Mr. P. K. Bora, standing counsel, Department of School Elementary, for respondent numbers 1, 2,
For all, my lord.
4. It is stated that the petitioner is presently serving at Khash Khamar, KHASH, KHAMR, ME School, in the Gauripur Education Block of District of Greek. And its headmaster expired on 22/12/2022. Due to non-appointment of the regular headmaster / headmaster in charge, in said Khas Khamar ME School, after the date of its regular headmaster on 22/12/2022, the school is facing difficulties. It is stated that she being the senior most teacher of the said ME school, one of the senior most, she should be considered to be given the charge. So should be allowed to serve as the headmaster in charge of the said ME school. In that regard, she has also submitted a representation on 26/12/2022 before the District Elementary Education Officer, Dhubri, through the Block Elementary Education Officer, Gauripur, to allow her to serve as the headmaster in charge and the secretary of the school managing committee of said Khas Khamar ME School. And the vacant post of headmaster of the said school, which is lying vacant since 22/12/2022 on the date of its headmaster, Imdad Hussain. Petitioner also stated that our said representation dated 26/12/2022 has not yet been disposed of by the DEO to brief. It is seen that the petitioner was initially appointed as an assistant teacher under centrally sponsored OBB scheme on 15/03/2001 for a period up to 31/03/2002. Later, pursuant to the order of the Director of Elementary Education Assam, in bracket D, our service was adjusted in a fixed pay of rupees 1,800. I am centrally sponsored OB Operation Blackboard 706. Fixed pay of rupees 1,800. Later, pursuant to the approval of the state government in the elementary education on 9/7/2010 and 21/7/2010, the Director of Elementary Education Assam, by an order dated 28/07/2010, adjusted or regularized the service of the petitioner in a fixed pay of rupees 1800. Properly, so he hired an assistant teacher at pin number Sapagor, CHAPGARH, Lower Primary School, the district of Dhubri. And posted her fixed pay and at a fixed pay of rupees 1800 and posted her at petition for 1475 Goripur Girls LP School. With the observation that she shall have to undergo junior basic training course from the academic session 2010 itself as amended in 2005 as required for lower primary school. It is stated by the petitioner by subsequent order dated 28/07/2010, the sum while adjusting / regularizing the service of the petitioner at fixed pay of rupees 1800 per month to her Mr.
Well,
Some difficulties are there to dispose of.
well,
There are certain things which are not coming out clear.
well.
Just directly to you.
Well,
On the next date fixed, the DEEO Dhubri shall apprise the court as to when the Khas Khamar Lower Primary School, the Gauripur Education Block of District Dhuri was amalgamated with Khas Khamar ME School. To place a copy of the order of such amalgamation. Further, on the date so fixed, the District Elementary Education Officer Dhuri shall apprise the court as to why the service of the petitioner has been confirmed against Khas Khamar ME School by the order under memo number WED-211 district court PT/5013/5047-53 dated 27/11/2020. Though the district elementary education officer by its order number EPD/OB/52/2010/DHU within bracket L.P.(17) dated 28/07/2010 adjusted the service adjusted our service a fixed pay of ₹1,800 per month against the vacant post of assistant teacher of lower primary school at 1475 Gauripur Girls Lower Primary School. Placed on 11th May. Okay, make it on 18th May. You've seen that even on earlier occasion, the district elementary education officer Dhubri did not fail to apprise the court with regard to the instructions sought for earlier on 20/03/2023. Failure on the part of the DEO Dhubri to apprise the court of the specific instructions as directed above. On the next that fixed I court shall consider to pass consequential order against him. Copy of this order to Mr.
Give your message. In this case also, your lordship, respondents were directed to bring instructions. The second.
On the next date fixed. The DEO to District Limited Education Deputy shall apprise the court who is the in charge headmaster of Messipara ME Madrasa the Bilasipara Education Block District B and what basis that say DEO Dhubri allowed team of the club to be the headmaster in charge of the said madrasa. Same day.
Deep level.
18th of May.
Within the day, I will serve today. Deep level.
Under part of the EU 2011.
Deeply obliged. Obliged.
May I please, Your Lordship, my lord, this, if Your Lordship remembers, this is regarding paid advertisements. My lord, in the first order, which my lord has put it down, it is in item number 31. If Your Lordship looks at the item number 31, Your Lordship will get the #31 and 32. similar matters. My lord, in item number 31, order dated 13/2/2023.
Please take your seat, Mr. But Mr. Abedin, in one of the order, it was observed that the issue before these issues in these petitions now pending before the division.
My lord, no, I'm coming to that, my lord. My lord, this I referred because only to give the indication what is the case, my lord. After that, my lord, another case was listed, that is the item number 32. On 27, my lord fixed this item, the order which my lord has read out just now. My lord, that was again refixed on 27/2/2023. When the AG appeared before this honorable court saying that they have got the substantial number of TAT pass candidates. In view of that order, the learned court in the interim kept 60 posts not to be filled up. Then, my lord, another writ petition was filed. And my lord, this honorable court was pleased to dismiss that case on the ground that they have approached after the last date of filing of the application. My lord, that case went on appeal. That case went on appeal. In the appeal, my lord, the case was considered and it was heard. The learned AG appeared before the court and they have filed an affidavit. And that affidavit is also the paragraph 8 of the affidavit is incorporated in the order. By virtue of that submission in that affidavit, ultimately the case was disposed of. But I may be allowed to pass this order. But only thing, my lord, that learned single judge's decision was not, I don't know how it missed that division bench.
this repetition should be disposed of in view of this division bench judgment.
I understand, my lord. I have, only thing is that as to when it will be done, that is not
That is
there.
a different thing.
I understand, I understand.
That's a different thing, but it's an assurance given by the government that for the post of any secondary schools, the date will no longer be required because they are going to amend the 2018 for the provincialized school rules and 2020 for the government secondary schools. So it was in an affidavit, that was also where the AG appeared. The statement has been made by the AG. So if any statement is made by the AG, it has synchronized.
Yes, I understand,
Right?
I understand.
So in that view of the matter, the Honorable Division Bench did not touch with the order or the finding of the learned single judge. Probably this could pass that order. Now that thing is this, and the petitioner, the appellants who prefer that the appeal against the order of the single judge, was clear that they will get an opportunity once to appear before the selection when such advertisements will be made after the amendment of the 2018 and 2024.
My lord, I understand my line, my lord,
So
now.
that is why
I understand.
probably these repetitions are infructuous.
Because of this, my lord, because of this division bench observation and the order and the stand of the government, I understand my limitation. I know my limitation also. But only one thing, if your lordship kindly looks, my lord, may not be of any use, which my lord has taken considered about the learned single judge decision of the year 2019. If you did not held every year, you should, and then you go further. But that part is not there in the.
That is the thing. Difficulty is why now the state government is going to withdraw the TATE part, because TATE is not a mandatory for the secondary school.
Yes.
So that division bench judgment passed by Honorable Division Bench Justice Bopanna and Justice Goswami. So that was that the TATE is required to be, it's a compulsory, it has to be conducted every year. That relates to only with
Elementary.
That was not extended to the secondary school.
It was our department has put it in the rule.
That's true.
Yes, my
That is
lord.
true, but thing is this, if this modified, because as a whole, you see, there are two sets. It is the NCT which guides the curriculum and everything for the purpose of under the RTA Act 2000. So where the TATE is the mandatory, but there is no such observation for upholding of any such teacher's eligibility test for the purpose of. It was a policy decision of the state government to have such kind of teacher's eligibility test for the purpose of induction in the secondary school.
I believe,
now that
I
policy
believe, my lord,
decision-
it was just inserted without even the decision.
Maybe we are, as of now,
Yes.
this is in the rule. If it is the wisdom of the government to remove it, because it is not mandatory in terms of the NCT guidelines. So they cannot remove, the state government cannot remove it from the elementary schools provisions because it's a mandatory provision.
They found it difficult to hold the TET every year for the elementary, which is mandatory. And inserting that in the year 2012 first. And now they realize that what we're supposed to do, that we cannot.
That is the affidavit of the state government.
I understand, my lord.
Also,
My lord, instead of infructuous, your lordship, with the observation of the writ appeal,
that will make.
these cases can be closed, my lord. And if your lordship requires, I can give the order affidavit copy also.
But Mr. Abedin, you are there only in item number 5.
Item 5 and item 31. 32 is my friend is there.
Who is there?
Is there.
For 32, so we'll dispose it of?
Yes,
all the matters? Yes. Line of division bench judgment?
Yes,
Over. 5, 31 and 30.
And my lord, those IS will merge with the.
Yes, will have no bearing now.
Yes, my lord.
Because it has to be modified. Those advertise, they have to make a fresh advertisement. We'll consider.
It's only because of the writ appeal order. Otherwise, I was ambitious of the order, my lord.
I will like infructuous.
Deeply obliged, my lord.
What's your good name?
K.I. Mazumdar.
Then item number 5 and 30. K.I. Mazumdar item number 32, opposite side of my Lipa. Mr. Kaushik appear or who appears? For the and the
My lord, in item 32, Mr. Senior Advocate, Mr. Yukan Nayar's name
assisted
maybe.
by
Yukan Nayar. Otherwise, I was supposed to call him, my lord, when
Okay,
the matter reaches. Deeply obliged.
Lordship, this matter is about the selection and approval of the president of School Development and Management Committee. On last occasion, record was called for.
Who is having the records? Who is having the records? This is regarding selection.
Mr. Chisti was there on last occasion.
Just will have it after some time. Let
Hello.
Mr. Chisti apprise the.
Proceed on last occasions, the matters were the item number 8 was extensively heard by your lordship. Lordship, I have already submitted my written arguments and also the list of judgments which have been relied upon, my lord. My lord, I would like to conclude my submission with some points, my lord, specific points, my lord. My lord, as per my first point is that as per the advertisement, there were two eligibility categories, category A and category B. My lord, as per the prescribed guidelines, a combined merit list shall be prepared from both of the categories, my lord. Lordship will kindly take my additional affidavit.
Now just tell us, we're just noting down. We'll not open it again.
Yes, my lord.
Just refresh it.
My lord,
But shortly.
As part of prescribed guidelines, a combined merit list shall be prepared, but
Then,
not a single candidate from the category B was selected. That is the first point. Second,
what do you want to say? There is a requirement to publish a combined merit list.
Yes, ma'am.
Right. Then what happened?
Not a single candidate from the category B was category 1 was selected. Category A was selected. And that is evident from a particular document on record, my lord. Can I show it to your?
Just not a single candidate from category was.
Yes, my lord. My lordship.
So according to you, in the combined merit list, there was no name from category A.
Category A, my lord.
Right. Then,
my lord, my second point is that the result sheet was not signed by the members of the selection committee, my lord, which is a very big anomaly, my lord. Result sheet was not signed, and it is appeared from the report of the CBO, my lord, Chief Business Officer. Thirdly, my lord, except respondent number 16, all private respondents are the appointments of all private respondents are found illegal in the CBO report, my lord. 15 out of the 28 candidates. The appointment of
out of 15, out of 28, 15 candidates.
15 candidates were found. The appointments of 15 candidates were found illegal, my lord. Though respondent number 16, the name of the respondent number 16 is not mentioned in the mentioned as illegal in the CBO report, but his appointment was also anomalous because, my lord, at the date of his appointment, he has not completed 3 years of service, my lord, which is required as part of the prescribed guidelines, my lord. Lastly, my lord, mischief in conducting the selection and appointment was so widespread and all pervasive, my lord, that it affects the result. It is the person who was unlawfully benefited cannot be identified, my lord. That is why my final prayer before your lordship is to set aside the entire select list, my lord. Thing of individual so-called notice is not required, my lord, in this case, in my humble submission.
Why?
My lord, because it is evident from the severe report that there were large-scale anomalies. No candidate from category B, category 1 was selected, category A was selected, my lord, and 15 of the total 28 candidates were already found illegal appointee, my lord. If your lordship kindly look at the entire circumstances in the case, my lord, I believe that opinion of this honorable court will be in favor of setting aside of the entire select list, my lord.
Mr. Sharma?
Yes, my lord. My lord, first of all, I'd like to submit that, my lord, in my affidavit opposition, I've categorically stated, my lord, that the person, that the petitioner here had applied for the ITI candidates. Whereas the person whom he is challenging is for the category B post. So there are two different posts, category A and category B post. So he being applied for category A, he has challenged the persons who have been employed against the category B post. And my lord may look into the prayer of the writ petition, my lord. In the prayer of the writ petition, he have clearly stated that what are the reliefs that he want for. My lord, the last time also, that the appointments order of respondent number 10, 11, 12, 13, 14 should be set aside. My lord, this to be set aside, my lord, I have been humbling praying for the last date also, this also. My lord, these people, they have already been absolved now. So my lord, to due course for removing from the job would be on a recourse of Article 311, my lord. My lord, in fact, a similar kind of case with regard to different circle was placed, and a division bench of this honorable High Court had directed the APDCL to send notice, and the last time I had given the judgment also, my lord. So, my lord, I think that would be finally also address the grievances by the petitioner, and the issue can also be dealt with, my lord, because as of now, my lord, there was no stay against the appointment of the private respondents. So they were appointed.
Just keep the number of DB judgment.
Last time.
Take it out, just give it the number. DB number.
Up to DC.
Mr. Sharma, can you give us the number of the writ appeal?
Yes, my lord. I'll just, I've been missing it right now. I'll just give it to my lord. It's by.
Okay. Consider it.
Yes, ma'am. And my lord, the
You
main
will
thing
just
is
give us the number of the DB judgment.
My lord, and then lastly, I would like to, my lord, the point out is that, my lord, this persons who have been there in the respondent, yes, there has been, the CVO has given a report. The report of the CVO, my lord, I'll place it on instruction, my lord. It's, and even it's there in the affidavit, they have filed.
No one had it.
No original to detail.
Yes, what do you like to show?
My lord, in the here the CVO have directly have stated that there has been illegal appointment against the respondents. So, my lord, the only recourse that he's asking is to set aside the appointments. So, my lord, if that has to be done, a direction has to be given by, because without recoursing the provision under Article 311, my lord, dismissing them as of this stage would affect the rights of the petitioner, even though even if the CBO report is there. The only thing that being a vigilance report, my lord, a direction has to be there by the court that the APDCL authority has to act upon this report, because this is an independent report by the APDCL itself, my lord, not directed by any other commission or by the APDCL itself, where it was not directed by any court's order that a report. It was only when we found that there has been anomaly on that regard we have taken a report. So it's an independent report. So my lord, so being an independent report, a direction of this court, and with the direction that with the recourse by asking the respondent as under 311 would be essential, my lord, to even if, my lord, if like to direct for them for removal of the and seeking for the prayer of under for setting aside the appointment. And when and on that course in the same line, there was the judgment of division bench, which I have already read. I'm going to give you. That is what I would like to pray for, my lord. And with regard to the second petition, my lord.
So because take it.
Yes, ma'am.
My lord, may see page 30, where is his prayer is that in view of the report submitted to permanently debar them from getting future appointment on the strength of such documents, and to direct the chairman of APDCL to initiate appropriate inquiry and disciplinary proceeding against the concerned who have issued the same. So he himself has prayed for that. So if he was himself, so we can say, because if this has to be there, so there will be stigmatic termination also. So that has to be looked on, my lord.
My lord, the facts of the second writ petition are defined, my lord. Kindly allow me to explain. My lord, as per the advertisement, only 28 posts were earmarked for the Rongya Electrical Circle. And the merit list was valid for a period of 1 year from the date of approval of the chairman, my lord. Even after expiry of the select list, a number of candidates were selected by backdoor entry, and appointments of those candidates are challenged in the item number 9, my lord. The facts are defined, my lord.
Even though, my lord, my lord, even though the facts are somehow related, my lord, may I just check both the petition once, my lord. Here he has said that further it is also prayed that your lordship would please to issue a direction that while the said representation, the opportunity of hearing should be afforded to your petitioner, and may be pleased to pass such order or future order as your lordship may deem fit. So he himself is considering for his representation, and in his main petition, which is praying Bhigu Thakurian, item number 9, he is paying for a direction for the before the court to direct the APDCL for an inquiry. So how is both the different, my lord? They're the same.
My lord, the appointments were defined. The appointments which are mentioned in the item number 9, my lord, were made after expiry of the select list, my lord, and they are prima facie bad, my lord. So I cannot make all the candidates a party to the case, because I don't know exactly how many candidates were selected after expiry of the final select list. So as these appointments are prima facie bad, I submitted a representation to the chairman to take action on those candidates. But my lord, in case of
Heard Mr. S. Vikas, Learned Counsel for the petitioner line, as well as Mr. S. M. Sir.
My lord, the writ appeal number I have found, my lord, it's 308 of 2021.
Just yes. The council petition for the respondent authority. Also heard Mr. G. Peku, government of Assam. Yes, writ appeal number
308 of 2021.
308,
my lord. I'll just read the
disposed of on when?
My lord, it was disposed of on 24th January 2023, where they have said that Mr. Nair, Learned Senior Counsel, appearing for respondent, has fairly submitted
records of the writ appeal number 308/2021, disposed of on 24/01/2023. It is submitted by Mr. Sharma and counsel for the petition, pending counsel petition. That issue involved in this petitions have been already considered in writ appeal number 308/2021, disposed of on 24/01/2023. Records of said writ appeal number 308/2021 be called.
Lordship, I sincerely apologize. Regarding item number 6, Lordship, so Mr. Christie is not available today, and record is with him.
He is not available today.
He is not available today. Record is with him, Lordship. They may be posted on 4th, Lordship, 4th of May.
Let us see. We don't know how much cases are there. Not on 4th. We'll have it on 8th or 9th. We'll first list on 8, then we'll see. So SMP Sister Learned Counsel. Council Department of on the prayer of the parties, list on 8. On the side, the 11 records will be placed before the court.
Right.
Six and 7. You are for 7.
Lordship, item number 10.
72. 62. Yes, Mr. Madunda.
Lordship, in this case, last occasion, Sheba was made party respondent. We served the copy and report was called for. My friend appears.
My lord, as per order of earlier order, my lord, we have verified, my lord. But my lord, we need some more time, my lord, because my lord, in the page number 24, my lord, duplicate certificate, my lord. Here, my lord, yes, my lord. Here, my lord, serial number is not legible, my lord. And after going through, my lord, roll number and
serial number you want 001,
my lord.
001.
Yes, ma'am.
858.
858.
Or 958 or 358, whatever you think. 958
or
358.
Yes, ma'am. My lord, as after going through the MRS and here, my lord, we have found here, my lord, in the MRS, my lord, against date of birth, my lord, here overwritten, my lord.
How come?
My lord,
In your office, how can it be overwritten?
Yes, my lord, it has been found, my lord, some overwritten. So, my lord, we need some more time, my lord, for.
Okay. Tell us when. Tell us when.
My lord,
Accordingly fix.
next week, my lord.
Not next week. Tenth. 10th of May. Yes, on 10th of May, and I'm with Mr. D.K. Roy, Standing Council. Sabah, to place the related instruction.
All right.
This shall reflect the name of Standing Council, Sabah, in the cause list. In terms of the direction, first earlier. Yes, Mr.
On the earlier occasion, Lordship had directed to file affidavit to the department. Lordship, I have filed the affidavit.
You have filed?
Yes, Lordship, but Lordship had directed us.
When did you file?
On 25th, Lordship. Lordship had directed to file by 21. Lordship, inadvertently, I could not file that on 25.
You have received a copy?
Yes, my lord.
Yes, sir.
Heard Mr. D.K. Roy, Council appearing for the petitioner, and Mr. A.R. Tawil, the Standing Council, Department of Higher Education. The submitted above that the respondent higher education have filed its affidavit in this matter on 25/04/2023, serving a copy of the same in the council for the petitioner, Mr. Roy, which we accepted. However, the said copy of the affidavit, copy of the affidavit, said affidavit of the director of has been filed by director of higher education or by whom?
Lordship, respondent number 2.
The affidavit of the director of higher education filed on 25 is not available in the case record. List on 10 along with the affidavit of the respondent. In the meanwhile, petitioner may file his reply if any with the affidavit of the respondent.
Obliged.
My lord, in this case, in earlier order, my lord, 4/4/2023, the matter was, my lord, tagged with the this present matter another repetition, and the my direction was to obtain the instruction the whether the who was the appointing authority of the my lord to get this. My lord, the first case 6910, they have filed the affidavit. But the so far the my lord second case is concerned 1371/2021 affidavit has not been filed, my lord.
Any affidavit? Nothing.
In the first case, we have filed, my lord.
What is your stand, Mr. Khatani?
An inquiry was conducted, my lord, and on the basis of the inquiry, my lord, he was neglected his duty assigned to him, my lord, as reported by the Deputy Commissioner Tinsukia, my lord. And he also did not cooperate with the officials and to receive the so-called notice also, my lord. Subsequently, my lord, his period of suspension has been regularized, and my lord, the punishment was increased stoppage of 1 annual increment with cumulative effect.
Then
Paragraph 14.
That is in the next case, my lord. This is not the first case.
This is on
This is on my
6910, my lord.
This is 1371.
1371, we have not filed affidavit, my lord.
This, my lord, the regularization, my lord, with the cumulative effect of the punishment, that is challenged in number 2. And my lord, most interesting, my lord, my approval of suspension was, my lord, came after 10 years. That too after reinstatement in the service. So, my lord, the period the remaining for more than 8 years, 11 months, and till, my lord, my suspension order was, my lord, reinstated. The entire suspension period is, my lord, vague. The inquiry report also, my lord, officer, I said annex, my lord. This is also very interesting, my lord. There was no specific any allegation is found, nothing discussion, my lord. Merely saying that that was, my lord, some negligence, my lord, annexer 10 at page 34. Lordship have a look on that, my lord. Inquiry report to Sri Ajit Datta under suspension, junior assistant of the district elementary education office, Tinsukia. Mr. Ajit Datta, Junior Assistant District Elementary Education Officer, Tinsukia, was attached at Honorable Deputy Commissioner Tinsukia at Food and Civil Supply Department at liaison assistant for midday meal work under the District Education Elementary Office, Tinsukia. Whereas for the regularity of the duty of the unauthorized absent in his service, he was suspended on such and such date, by order such and such, as per the discussion with the Deputy Commissioner Tinsukia. As per the letter number such and such from the District Elementary Education Officer Tinsukia, an inquiry committee was constituted and it was carried out an inquiry. The committee, after careful observation, all the available evidence related to the case, has found that Mr. Ajit Datta has remained suspended for 8 years, 3 months till now. The committee recommended to reinstate the service of Mr. Ajit Datta and stop one increment. So far the reinstate part was there, that was done, and subsequently, while my period was regularized, that penalty was imposed, but not before that. By this time I was reinstated. When I submitted the application for regularization of that my suspension period on that ground, because the approval was not there. By this time my suspension has reinstated has come.
Tell us one thing, that 6910/2021.
My lord.
Yes, sir.
6910/2021. Since your suspension period has been regularized.
Yes, ma'am.
Only with the imposition of
this penalty portion.
Only one penalty, that is
1 year
of one increment.
One such increment.
Yes, my lord.
I think the first repetition has become infrastructure.
After this, my lord, is not, my lord. Yes.
Because of this order.
But one thing, same thing I have. Yes.
The second repetition.
Yes. Same thing also I repeating till, my lord, they regarding.
Just 2 minutes.
But my whole stand is this, my lord, the suspension period.
Mr. P. Mahanta. And counsel for the petition. And Mr. N.J. Khataniya, standing counsel, Department of School Education. For the respondent numbers 1, 2, 3. Also heard Mr. G. Pegu, Government Advocate Assam. For the respondent numbers 6 also. So 1, 2, 3, 1, 2, 3, and 6. And Mr. Zipper, Government Advocate Assam, for the respondent numbers. While serving as an LDA in the office of the District Elementary Education Officer, Law Division, LDA DU Tinsukia, the Director of Elementary Education Assam.
Issue notice. I already responded. Notice of motion, returnable, response number 45.
Deputed him
number 1. Mojender for
the office of the Deputy Commissioner in Chukia.
Yes.
In the office of the Assistant Director, Food and Civil Supplies, MCA, Tinsukia, under Deputy Commissioner Tinsukia, as a liaison assistant, LAI, come LDA. To look after the liaison come LD लिखते ना under cook midday meal scheme in Tinsukia district. Accordingly, Deputy he was relieved from the on 23/03/2007. He was released from the office of the DEO Tinsukia. As the petitioner, because of his negligence and habitual absence in duty, the Deputy Commissioner in Chukia wrote against the petitioner pursuant to which he was placed under suspension. By the DEO Tinsukia wide order dated 13/07/2011. Later, the petitioner was allowed to draw subsistence allowance initially at the 50% and thereafter at 75% of pay, plus plus proportionate amount of other allowances as admissible under the rules. Disciplinary proceeding was initiated against the petitioner, with 4 charges to which the petitioner submitted his reply. Even second so-called notice was issued upon him. Since the proceeding, departmental proceeding initiated against the petitioner way back in 2011 and kept the petitioner under suspension since long for more than 8.5 years. Being aggrieved, the petitioner preferred the present date petition. Preferred the present 8.5 years. For more than 10 years.
frame amongst others to set aside his suspension order pending department proceeding, to set aside the inquiry report against him, as well as the order dated 23/08/2001 issued by the Director of Elementary Education Assam approving the suspension of the petitioner. Suspension order of the petitioner dated 13/7/2011 issued by the DO Tinsukia after more than 10 years. To release his entire salary during his suspension period. Till his joining service on 13/7 from 13/7/2011 to 13/06/2022. The respondent authorities in the elementary education department in his departmental proceeding found the charges established and under provisions of the Assam Services within the Discipline and Appeal close to 1964. Imposed penalty by an order dated 02/02/2022 by stoppage of one annual increment with cumulative effect, regularizing his period of suspension. In view of the above, the petitioner shall be paid his unpaid dues during the period of suspension for the period from 13/7/2011 to 13/02/2022. Deducting the subsistence allowance of 50 and 75% already paid to him. With the above observation, this petition stands. 6910 by extent above. Second. Same part, Mr. Mr. Anjay continues can you counsel for 1, 2, 3, 6 GPay group covenant to take a sum for the rest of the 4 entities. Notice in this case was issued on 28/02/2023. The respondent authorities are yet to file their appeal. On the next date fixed, the Director of Elementary Education Assam shall place the record of PCA-10/2019 in original, wherein Director of Elementary Education the said director passed the order number ECA-10/2019/61 on 23/08/2021 as well as ECA-10/2019/98 dated 02/02/2022. Further, the district elementary education officer in Chukia they say it shall also place the records of PEO SUS 55/95 11 in which the said authority issued a suspension order against the petitioner on 13/07/2021. As well as on the records of EEO/SUS/55/95/2019. Wherein the DEO in Sukia passed an order on 5/12/2019 against the petitioner in service with stoppage of 1 annual improvement. Order written 5/12/2019. List on. Fifteenth of May. Not 15th. 16th of May. Copy of this order to Mr. N. J. Patani. On the part of the respondent authority, place the 11 records in our
May I pay one thing, my lord? My lord, the petitioner's next promotion avenue, it has been already, my lord. Next time we'll see. My lord,
Yes, Mr. Midhi.
My lord, in that case, my lord, this direction on last date, my lord, to produce the record, my lord. The selection committee of the school, my lord. My lord, there is a appeal was also filed, my lord, but they
Right. Who is appearing for the respondents? Secondary education.
Yes, my lord. Basically, 423 this starts, my lord. This case, my lord, 423, my lord.
Because records will be required because relating to the selection of principal.
So far, my knowledge is, my lord, there is an excerpt of the case 49, my lord. This was the last, my lord, the proposal filed by the school committee, my lord. But thereafter, there is no, and that was on the basis of that, my lord, this knowledge of the coordinate bench, my lord, the order of the contempt petition was, my lord, passed, my lord.
Is 49 or 100?
49. 409. 409. 409. In the contempt with the school authority, my lord, filed an affidavit, my lord.
When?
Affidavit, my lord, is page, my lord, 322, my lord. Here, my lord, it was, my lord, this mentioned about this, that the proposal, my lord, which was submitted before the Director of Secondary Education, my lord, on 11 February 2022. The affidavit was filed by the school committee, my lord. When order was passed by coordinate bench, my lord, in contempt petition, my lord, your lordship may. This order is, my lord, page 423, my lord. Well, page 428, my lord, this second paragraph, my lord, second paragraph, last line, my lord. In doing so, the material transmitted by the school selection committee shall be constituted to be the material to be taken on the consideration on arriving at decision and view expressed by the school selection committee for rejecting the candidature of the petitioner Abdul Aziz Ahmed for the reason that he had completed the post-graduation qualification without permission to the appropriate authority be not taken in consideration. The state selection board shall come to an independent conclusion of its own and on the state's issue as per law. Here, the allegation was, my lord, the respondent was 6 here in contempt his petitioner, my lord. His post graduation was not as per law, my lord, without the permission of the authority, my lord. And my lord, thereafter, my lord, they went finally passed the order, my lord, the contempt petition, my lord. Based on paragraph 23, we have to take a note the provision of Rule 13. Rule 13 of the Rule 2010. It is the prerogative of the school committee to prepare a panel of the 3 candidates upon the qualities as such as leadership skill, administrative ability, integrity, commanding personality, and it is not the prerogative of the school committee to select the appropriate candidate. Under Rule 13, it is the state selection board which will make the selection for the post of principal. For such point of view, the provision of this order would be consistent with the provision of Rule 13, which required a state selection committee, state selection board to take a decision as indicated above. My lord, this was the direction of the contempt petition, my lord. My lord, here what happened, my lord? Initially the petitioner, he was appointed as principal, my lord.
No, you understand.
Yes, my lord. But the space, my lord, 409, my lord. This was the proposal, my lord. It was not considered, my lord. And one considering the order of the contempt petition, my lord. That was order also not completely complied, my lord. Completely complied, my lord. They are minus, my lord. They are minus, my lord. Page 435, my lord. 435, my lord. Two 268 is the order of the division investment. 268, my lord. 268 order of the division investment. Relevant part, my lord, this point, my lord. After hearing the counsel for parties, we find no anomaly in the order passed by learned single judge. Accordingly, we dispose of the writ appeal directing the school selection committee to reconsider the matter as per Rule 13 of the Assam Secondary Education Provincial Rule 10 and forward the same to the Director of Secondary Education Assam for approval. While reconsidering the matter, school selection committee shall also look into the contention of the writ appellants. The writ petitioner was not qualified as he had not done his post graduation as per law. This was the direction of the division bench. And minus, this page starts from the 435, my lord. This letter, my lord. There is no whisper about the judgment of the order of the division bench, my lord. Only they reflected the order of the contempt petition itself, my lord. Contempt petition, my lord. My lord, this page from